warm good morning to all the viewers of the live program, and very good morning to our dear director, ma'am, Dr. Mayuri Pandya, and Dr. Shashikala Gurpur, ma'am. Good morning, ma'am. We are so glad and happy to have you on the e-platform of GLS Law College. Uh, I request Director of GLS Law College, Dr. Mayuri Pandya, to offer her welcome address to our esteemed guest of today. Dr. Mayuri Pandya is the director of GLS Law College. Ma'am is second.
Batman, that's okay. That's okay. Thank you.
Ma'am, just
Ma'am,
viewers knowledge.
uh, Ma'am, good morning to you, and I welcome you on behalf of GLS Law College and Gujarat Law Society, all the viewers of today's this special session on the legal research methodology. Today, we as a family at GLS, we are very happy, ma'am, that you have accepted our invitation. And we are so much moved with emotions because today morning only, just now before 5 minutes, I came to know that ma'am she undergone one surgery of gallbladder, and I was unaware of it. But when I invited and requested, ma'am has accepted, and today is her last day at home because she is taking rest. Ma'am, no words for your dedication and the gesture that you have shown to, especially for my students. So on behalf of all the faculties and all of the students, I express a sense of gratitude, ma'am. Thank you so much. And I wish that your health soon be will good, and because we need you. This is especially for my students that the name Dr. Shashikala Gurpur, the name itself she is well known so far as the legal fraternity is concerned. She is known for her legal acumen. Ma'am is so humble. Now I need not to say anything for her humbleness and her dedication. And ma'am has lot of, when it comes to the legal research, the contribution as an academic lawyer is unbeatable, and her name in the legal spheres, anybody in India will take with utmost respect. She was also the member of the Law Commission of India, and I am very happy that, ma'am, you have accepted our invitation and you are with us. I remember because this is the topic of today is the contemporary dimensions on the legal research methodology. I remember one thing that I'm talking of before 25 years when I started my research on environmental law, and I remember that one of the project that was going on at the Muthia village. There is a one Muthia village, and there were a lot of pollution problems at that time. And even if you see the cows when they used to go from that particular village because of a few of the industries and the waste coming out of it, those cows, they had blood in their legs. One of my friend who was working in that research project, so I was just passed out my master's and was in search of some subject where to go for the research. And I was just, when I came across and we were discussing, and I told that I would like to do something in this particular area. Then he said, Mayuri, what are you talking? What an academic lawyer can do? How a law person can do any sort of research? There, you can't do anything. And I was so much shocked. I'm talking of before 25, 26 years, ma'am. And that was the kind of the era where there was a thinking process that nothing can be done so far as the law is concerned. How you can go, oh, if it is a science, yes, fine. If it is another branch of the social science, yes, you can go for the research. And if we go into if we see the history, we find that the always the academic lawyers, they go into the research and they analyze, they rely on the primary and the secondary sources, the judgments, the case comments, and so on. This is the traditional journey of an academic lawyer. So this today's session is an attempt for all my students especially to learn from a person who is expert in her field, and she will give us a new dimension so far as the legal research is concerned. Once again, I welcome you, ma'am, and thank you so much.
Thank you. Yeah.
Thank you so much, ma'am, uh, for your kind words, Dr. Mayuri Pandya, Director, ma'am, of JLS Law College. As ma'am rightly said, that today the topic is contemporary dimensions of legal research methodology, and as ma'am rightly said, that with Dr. Shashikala Gurpur and as an expert, we will be having one more dimension added to it. So I would just like to say that it is truly believed that the common facts of today are the products of yesterday's research. So I'm sure that after ma'am's input and insight uh, to this particular topic, that to contemporary research, definitely are all the listeners, viewers, and specifically students will definitely have the new wing and new horizon will open for the research, which will be an important product and project for tomorrow. And with that, I would like to say a few facts about Dr. Shashikala Gurpur, our esteemed guest. Ma'am is a distinguished academician and an orator, having presented more than 200 invited lectures, workshops, and seminars across India, Thailand, US, UK, Ireland, Germany, Australia, Canada, and UAE. Ma'am is the director of Symbiosis Law School, Pune since 2007, and she is the member of 19th Law Commission of India and National Judicial Academic Council. Ma'am has also a wide range of experience and expertise in teaching, research, and industry. And ma'am had been working as an HR manager and in administration in an MNC in Abu Dhabi, UAE, and has more than 24 years of teaching experience, and which includes many of the reputed institutions and other things. Ma'am has also won the NPS Sector Research Grant under Ford Foundation on gender advocacy. Gender is one of the ma'am's area where she would like to throw light upon. And once when it was started, just ma'am was setting all the technical part. Ma'am just said that yes, in the it is just the end of the year when almost everybody is in celebration mood. See, the women are at work, as ma'am rightly said. That gives the proof of ma'am's dedication and her love for the work. Over to you, ma'am. Our students are so eager and they want to know about your insight and your view about contemporary dimensions of legal research methodology. Over to an expert, Dr. Shashikala Gurpur, ma'am.
Thank you, Dr. Mehta, for that generous introduction, and Dr. Mayuri for giving me this opportunity, and all those who are present there. A very warm good morning. And first of all, I apologize for losing first 10 minutes in technical glitches from my side. But the patience and the forbearance of the team is really remarkable, and also the meticulous attention and communication with which this session has been organized is praiseworthy. Gujarat has been my favorite place for last more than 10 years, being engaged in Vadodara, being engaged in Nirma, being engaged in GNLU, and now your law school has also been in the fraternity. Alongside, we have Veer Narmad University as well, where I go as an examiner. Now, addressing today's students, who must be a combination of students from across undergraduate, postgraduate, and some scholars, some faculty, creating that common denominator is a challenge. So, we thought some reflections on the contemporary dimensions of legal research, where I'm trying to synthesize what I do in my PhD training in various law schools for 2 days into 1 hour. So, I can only afford to give you a little glimpse. In the beginning, I would like to say and respond to the two observations made. One is Professor Pandya's own engagement with environmental law research and the skepticism which was encountered by her on the relevance of legal academics in research. Madam, if you look at the Bhopal case, but for the field-based research initiated by late Mulchand Sharma and Dr. Upendra Bakshi and Amita Danda and some of these scholars, the entire cry of those who lost, the poor, would have been a cry in the wilderness. It came into the legal books because of the field-based research that legal academics did and formulated a framework and then sat with the practitioners. Secondly, the whole lot of MC Mehta series of cases are based on field-based research, which made entry into the formulation of litigation. A number of other public interest litigations, whether by Swami Agnivesh or by number of other non-governmental organizations, including Dr. Rajiv Dhawan's own engagement with Narmada Bachao Andolan, are all issues where field-based research guided by legal academics along with other transdisciplinary experts have been in the forefront. I'm going to give you a special reflection on something called community-based law reform research. I have come a full circle in my own life, which my CV doesn't say. I began my career in Mangalore way back in 1990. And then I had the good opportunity when the National Law School was just being formed then, under the guidance of Dr. Menon, to engage in a competition, my team of students. So I was guiding and I was creating a platform of learning for them in those days. So we picked the problem of agrarian worker women and we entered this competition to give community-based law reform proposals. And I tell you, we won the All India level award because our proposal was based on the authentic realities of agrarian worker women and the changing landscape of Western Karnataka into industrialization and the gross poverty in which these women lived. Because of both public patriarchy and private patriarchy. Patriarchy in terms of discrimination in wages, in terms of the pain they had to go to at home as the providers and then go back to work as well, the double burden that women bore. So this research warranted the attention, and my academic journey was quite a you can say quite a zoom because of the field-based research that I did. Dr. Upendra Bakshi was also my inspiration because in Gujarat, he did a lot of research on the tribal panchayats and Justice Bhagavati's own inspiration from community-based realities leading to legal services authority and legal aid kind of reflections and development of whole jurisprudence. In comparison, if you see in Europe or England or in America, academics are the ones who guide the future direction of law. Any academic reflecting on the judgment is taken very seriously. In India, this art of writing critique on judgments or the science of it has not been trained. I learned these basics in my career stint in Ireland. So a little reflection I'm going to share with you. Most of the law schools don't teach this. It's like in medical school, how you teach the pulse. In law school, you have to teach how to do the pulse of law, how to do the anatomy of law. For the benefit of all of you, if you have read this report called Educating Lawyers, which is the Carnegie report, so-called famous Carnegie report on quality legal education, it talks about how medical education has fulfilled all the requirements of professional education and has a transnational protocol or a kind of structure which it follows in quality. Legal education is much far away from that. Either it is favoring too much of clinician approach by creating manpower or human resource for the court-based careers, or some of the law schools as they are engaging now into corporate careers, and the public service dimension of profession as a mandatory requirement to engage with the community doesn't seem to be taken care of. Now, that is exactly where, as researchers, and in your legal research assignments, whether in the form of projects, etc., as late Dr. Menon said, we can mandate children to look around, to feel the community. Now, more and more, generally, universities are to be creating knowledge in the form of or through the tool of research. Otherwise, it's much less of a university. Generally, this is the trend that is all over the world. And in India, now with our current incumbency, it's growing strongly with the new education policy also. University means research university, or degree giving university with moderate focus on research, or degree giving colleges slowly graduating into universities. That is a vision in the new education policy for the higher education. So research is in the core. But how do you do this research? In science, the protocols are settled. In medicine, they are settled. But what about law? In law, research has been most of the time doctrinal research, and doctrinal research, in my opinion, has been more of armchair research, looking at the references, collecting them, and giving a viewpoint. But testing these viewpoints in what I call impacting life kind of context is not being done very often. Sometimes, we also feel the ivory tower of our judiciary or legislature doesn't seem to be taking into consideration the reality. As we saw in the COVID crisis time, the number of judgments which came reflecting on the migrants was a shock to all of us, to the apathy and the human rights indifference, where the lawyers had to do the research and wake up the conscience of the court. So, as who said that? Advocate Sanjay Hegde said that there was a Mary Antoinette, means the queen-like clinician indifference being exhibited by the Supreme Court. So, this is where, if you look at other jurisdictions, for example, there is this Harvard researcher. Then there is Kasman, and then we have the entire body of privacy research which emerged in 1920s as a Harvard Law School essay, which later made its entry as part of fundamental rights, as an unenumerated right, as part of right to life, and later became the fully fledged right in some jurisdictions, and in our country being reflected in judgments. And today we know that right to privacy is there as a sacrosanct total right. Now, this path of evolution began from the law school. Most of us do not seem to know that. And a lot of our constitutional evolution also happened through the academic research. Let's not forget that. And my urging is continuing Dr. Menon's enterprise to look at community-based law reform, which I did as the member of the Law Commission in constituting a kind of deliberation in Pune. And prior to that, Dr. Menon is the member of the criminal justice reforms, also did that in India in 4 zones. We did field-based research on the working of the high courts and best practices. We saw that high court in Gujarat or courts in Gujarat would take longer pendency period for cases, whereas comparatively Karnataka's is much less, Maharashtra's is midway between the two. So all these kinds of legal institutions, legal practices do need academic research. So the problem is academic research is deviated from what is actually required by the legal institutions and the community. Just compare it with the Indian Council of Medical Research, ICMR. ICMR has got a very strict ethical guideline. It has got a very strict framework which keeps training people every now and then on the emerging research trends. So Dr. Chimney, myself, and Dr. Menon, including Dr. Rajkumar, way back in 2013, we urged the government, and later on I made a presentation in the Rajya Sabha also, that we need to create an Indian Council for Legal Research, which will take care of this research need. We should not leave it to the ad hoc, individualized understanding of research. We need to create a think tank. We need to create a reform. I don't see government taking that initiative. I'm hoping this government, which has done the National Medical Commission, National Nursing Commission Act, I hope it will do a Legal Commission Act. But whether our Bar Council friends will be happy with it, because they are also the conscience keepers of the Constitution, I have a lot of respect, because they have really stood up to this crisis as the defenders of human rights. But in this matter, it's a very sensitive matter to them also. Consensus has been difficult even in Menon's own lifetime. In that case, some private initiatives can act as a via media. So I expect your law school also to play that kind of role in standardizing legal research, in trying to set a kind of standard. So my little attempt is to touch upon those areas which are very much required to set this new trend in the line of ICMR approach to reality and research. I hope I have your permission to run the PPT. I hope all of you are seeing the PPT. So my CV was read. So these are the different engagements that I have been in some book chapters, articles, PhD guidance, etc. That's why I take the courage to come to you and talk. So my quick presentation for next 40 minutes. I hope all of
Ma'am,
you can.
yes, ma'am. Just a simple suggestion, ma'am. If you will give F5, so the whole screen will be of your PPT. If you can just press F5, key F5.
Okay, so that,
Yes, ma'am.
yeah, yeah.
Yes, ma'am.
So it's a slideshow mode. I keep that because I'll keep a watch on the time. So next 40 minutes or 35 minutes, I'll reflect on that. So first question is, I'm arranging my presentation on these 7 points. First is, what is research? Why legal research? Second is, what are the approaches to legal research? Third is, what is a blueprint or outline of legal research? Fourth is this law reformed research, in that community-based research. And then how do you identify, or what are the parameters of quality research? And how do you make an impact pathway in case of research? And how do you convert your research into publications? What are the reflections on that? And then we call it as conducting responsible research. In other words, how do you conduct your research in such a way that you are sensitive to the stakeholders, and you are also mindful of the vulnerable of the society, that your enthusiasm to complete your research, you think you know the truth, or you are trying to explore the truth, therefore you have every right, without sensitivity to your ethical responsibility. That's why I put this section also. Now, all of us know that research is a scientific enterprise for seeking truth. So, our journey is to find the truth. And the truth, as all of us know, it is like blind people touching the elephant, the Upanishadic story. That some of us may approach that elephant from the tail and say that truth is only this tail. Some of us may approach from the trunk and we may say that truth is this. So, a real truth is multifaceted. It needs all kinds of perspectives to come in. So, how do you make that your search for truth is anchored in the existing known truths, and then it is taking the truth to a different revelation which has not been done in the existing approach? So, it depends on which part of the elephant you are touching, and which angle you are taking, and you acknowledge that you are standing only on this part and you have not touched the other part, or the other part connects to this in this way. So that all depends on the design that you adopt. From the beginning, if you are making this very clear, then your research will be viewed from that scope and limitation point of view, and it will be appreciated with that. But if you make tall claims, for example, when I evaluate thesis, people say, I'm going to adopt a combination of methods. There will be some empirical data as well. And I search the whole thesis, empirical study is not done. So instead of that, you can say that for some reasons, empirical study has not been done. That's the limitation of this thesis. And the scope is that this is only covering the doctrinal approach. So this way, from the beginning, you have to be very clear when you're presenting your research. Secondly, the very word research and the very word sire in science are interconnected. Sire means to know. So the word science comes from the probing or the knowing, and that is the approach. And every research is scientific inquiry because it is about that search. And the word search comes from sarkare, which means to go round in circles, to go and to not to stop your movement of probing the truth. So scientific research is characterized by 2 points. One is being objective, not to put your personal bias, your personal opinion, but to follow a given protocol or method and arrive at your conclusion about the problem that you are taking up. Secondly, neutral. You are not being so in objectivity, you are not going according to your nose, but according to the set structure or methodology of research. In neutrality, you are not taking a bias, but you are using either statistical method or qualitative analysis method based on the structure and categories of knowledge that have been set by earlier researchers. So it's by neutral, we mean neutral in value. It's very objectively and without personal engagement, it has been done. Although latest emergence of works by social scientists and others has influenced law as well, if you read the jurisprudence books, you may come across a school called postmodernist school, and you have feminist school. These are looking at this neutrality and objectivity question with the criticism. They are telling that sometimes your statistical analysis may not reflect the reality of the vulnerable, like children or people in the prison. So you may have to do what we call qualitative case study method, whereby you collect what those people have to say, their narratives are captured, and based on that you are making your conclusion about the research problem, or you are taking it in addition to statistics. So objectivity and neutrality depending on the method they are saying, and they are challenging the objectivity of scientific method also. So I'm just giving you a clue so that you are mindful of this, and you are not going to conclude, you are just keeping your mind open. I'll give you an example. We had the privilege of advising government of Karnataka on the sex workers violation of rights. I was invited to the table to summarize the mess that they had created, and we had to put it in a report form. It was a research. It was rather, you can say, a committee which was asked to probe the way in which the policy is reflecting on the sex workers, female sex workers of Karnataka. So there were 10,000, I mean, there were officially in the books about 1,10,000 sex workers. Out of them, 10,000 were chosen as sample through their different organizations and locations. And there was a skewed sample because 40% of them were in Bangalore city alone. Rest of them were distributed in certain pockets, and certain pockets in Karnataka were the supply zones, like the backward Hyderabad, Karnataka, and borderline Karnataka districts, which were in abject poverty and famine. So we were doing this statistical analysis of their socioeconomic. I mean, there were 4 questions given on socioeconomic situation, type of sex work, exploitation, health issues, and their children's situation. So this was all in the light of the Supreme Court decision called Buddhadev Karmaskar case, where Justice Karju and Justice Gyan Sudha Mishra had given a mandate that all state governments and others should take initiative to protect the rights of these sex workers, because the case involved the murder of a sex worker in the Calcutta red light area. Now, based on that, Karnataka government had taken it up. Now, 10,000 interviews were there, and there were also probing of case studies of 3,000 sex workers' narratives. Now, these narratives revealed a different kind of outlook than the statistics. So the two had to be triangulated, and then policy reflections were to be culled out, and reforms had to be culled out. There they got stuck because they didn't have the methodological clarity. They did not have the connection between government's mandate and how to bring out the policy formulation text, and how to see that this policy is rolled out. How do you make recommendations for policy? That is exactly where my expertise was utilized. And we were able to roll out 600 crores budget allocation based on this convincing report to the governor and the chief minister. 1,000 houses were distributed in phase 1, and 4 production centers were created in 4 zones of Karnataka to those women who opted out of sex work at some point. So here, the very word scientific, economic, sociometric kind of analysis was not enough. We had to collect their narrative to know. And one of the narratives revealed that 40% of them were trafficked as little girls. And the way in which they were narrating, we had to bring in the ethical dimension of bringing a social worker, giving them multiple opportunities, making them go through psychiatric treatment, which was never attended by their brothel houses or even the government's reception centers. So this is where responsible research and objectivity and neutrality need to be viewed. Now, in scientific inquiry, we have natural sciences like physics, chemistry, biology, biological sciences, and they are characterized by experiment, observation, inference. That means in the controlled conditions of the lab, certain materials are experimented with, means you give a stimulus to them. For example, you cut open the dissection in the leech's body and you put your scalpel in a particular area and you see how the leech's muscles are, intestines are. So there you are using your senses, empirical senses. and then you are observing and you're making notes. So experiment, observation, inference, you draw a conclusion based on that. So how do we do that in a social lab, like in the court of law, or looking at the text of the law and the reality of the people, or a legislation which is passed by any of the legislatures and the people who are going to be impacted by that legislation? So this is where we see that social sciences research needs to be viewed in the lab of society, and it cannot be empirically validated unless you understand its limitation, because human beings are unpredictable. They are not like the leeches which are bolted to the dissection table. They are not like the standardized calibrated burettes or pipettes or test tubes where you measure and put, because you measure and put, let us say, two news items and try to see their behavioral changes on the law, but then they also have an inherent brain process. They have their past baggage of influence from the media, their educational background, family background. So human entity cannot be in a live organic context, is spontaneous and changeable. Therefore, we cannot be empirically validating everything. Therefore, there are certain limitations which we have to acknowledge. And then the truth. The truth in the beginning is, as I told you, elephant's case. We have this famous reflective thinking, where when we see with the sense experience the relationship between different phenomena, for example, aged people becoming more forgetful, or somebody who is not able to understand the ways of the world committing more mistakes in relationships or in treatment decisions or in educational performance. Now this kind of process of observing the reality and then forming our conclusions can be enhanced by science. But then when you're trying to make those beyond your tabulated notes, when you're trying to see and interpret the causal or associated relationship, let us say, between temperature and pressure, or forgetfulness and age, or criminality and slum dwelling, then in those cases it's your reflective thinking, which is philosophical and abstraction of the scientific conclusion, where both your thought process and intuition come to play. Now this kind of leap in the thinking, what Dewey Kelly, these educational psychologists call deductive leap, in arriving at that conclusion, the leap that you do is movement from science to philosophy. That's why it's very important that you have very strong theoretical knowledge. You do your proper literature understanding before you formulate a research problem. And then sometimes, directly you may conclude you are having a theory and you're experimenting. For example, there's a theory that tradition and modernity are opposite each other. I am applying it to a series of judgments about women's rights, including the Shabarimala, Narsu Appamali. Now, there I am doing existing theory, I am applying. There may be another approach that I take. I see all the judgments of Justice Krishna Iyer and I say how his commitment to left-wing ideology is seen. So here I am developing a theory. When you develop a theory from empirical data, it is deductive thinking. When you are applying a theory to the empirical data, it is inductive thinking. So this is how theory to reality, reality to theory. Deducing from reality is deductive. Inducing the theory into reality is inductive. So sometimes in a research, both these happen when we combine the methodologies and try to see different facets of truth. Like in sex workers' case, when I wanted to see how exactly their reality was and their psychosocial dynamic was, I was using the case study method. But when I wanted to see whether the socioeconomic indicators which are tested in other countries' research on sex workers is reflected in Karnataka, I was using my survey questionnaire. So both together I was able to interpret, because my purpose there was to give priority areas for policy reform. So please understand that you have to be very, very alert in your research. Anytime you should be open to shift. Anytime you should be open to change your approach and be open to incorporate new kinds of facts. Now, we push the boundaries of existing theory. So, theory building is a very important enterprise at the end of the scientific inquiry, because you know how from Newton to Faraday to Einstein, the entire idea of energy was changing in physics. In our case, from Lord Atkins, Donoghue versus Stevenson, today Consumer Protection Act all over the world, and today Competition Act, which is coming up, how the boundaries of law formation got pushed and theory got built from the monolithic, monopolistic stronghold of business to the rights of the consumers. But there is a reverse happening in e-commerce, so maybe new theories are required. So please go by the observation of the two academics who spoke in the beginning, that academic research drives questions, challenges, the given by some of the stakeholders in the system. We have the advantage of this 360-degree neutral objective analysis of the truth that is given. How is scientific research applied in legal research? Every legal research is a research for justice. That's what I believe. So first of all, we have to know what are the rights question we are asking. Where do rights come from? Rights come from the interests which are recognized and protected by law. So we have to be aware of which legislation or which provision or which generic global provision, human rights structure, or national provision like constitution, what kind of rights are arising in the given research problem. Then the scientific learning we do is looking at it from unbiased eyes, in the sense of not believing that judges are the sacred soul source of wisdom, that judges are human, and those judges are also biased sometimes by circumstances or ideology, or they may also be oblivious, or the lawyers who were guiding them were not giving because judge so moto seldom judges carve out their own principle, because we are a common law jurisdiction. On the other hand, in the European continental tradition, judges create the principles or judges apply the principles. So there is more scope for maneuvering. Here we are bound by stare decisis doctrine. We may do in legal research why certain law has worked, why it hasn't worked, how it works, how it doesn't work. For example, if you look at women's empowerment, Kerala has a very high index. On the other hand, when you look at a state, Bimaru state like Bihar, Madhya Pradesh, Rajasthan, Uttar Pradesh, why the law doesn't tick there, and how the situation, let us not conclude, how the situation is changing under leadership. So this is how you as a researcher will be looking at legal research as a research to see whether the idea of justice, the fairness, equity are being protected and strengthened. Open inquiring mind is required for us, not to be putting anyone on pedestal. We have a tendency to pedestalize judges, etc. And then alternate strategies. If the court is working well and good, if the provision is working well and good, what are the other strategies they have adopted? For example, why Justice Markandeya Kaju goes beyond the brief in terms of conducting this kind of field-based research in 3 red light areas and asking the state governments to take cognizance of their responsibility, and why other judges do not do it. Or how many judges have made governmental authorities to give better governance. So those are alternate strategies. And they will help us to help the court to make the decision, or the governance system to make the decision. For example, we are researching on urban governance model in slums. How few particular slums did not get affected by COVID because there were internal mechanisms and leaderships which were already there. So this is how when you are picking a problem for research, you should always see how it is going to help the system and impact more people and protect the constitution and strengthen the deliverance of justice. You can join forces with other scholars. For example, if you're looking at legal aid services authorities collaboration by law schools, you alone cannot do it as a lawyer. You may tend to write as a teacher a very good report, but you bring a sociologist or a social worker who will give you methodological understanding to see how a service, social service, has to be measured, how its impact has to be understood. Similarly, if you want to look at artificial intelligence and law, you will require algorithmic expert from the artificial intelligence field, how those algorithms work and how do they get influenced. And then we have in our legal research the framework of values, justice, and rights, how they are interconnected. What are the lurching values, as Justice Oliver Wendell Holmes said? We may have to ascertain the nature of the policy, or its purpose, or its objective, its relevance, its adequacy, its usefulness, utility, its impact, its efficacy. That's why some of the PhD thesis, if you go to this Shodh Ganga in the University Grants Commission, it will tell you how the PhD thesis is titled. And then you have to evaluate the approach taken by courts or their application in a given situation. As I told you, Narso Appamali or Shabarimala, or Awag case, the gender dimension, or the recent Navjot Singh Johar case, or the latest bill which has been coming on transgenders. And what is a new set of vocabulary emerging there? How is have they bothered to see family law in that context? Have they bothered to see surrogacy law in that context? They haven't. It has been very, very isolated and a kind of standalone approach, which needs to be now further looked into. Examining theories or doctrines, I gave you the example. We have this institutional theory concept in sociology, which we were trying to apply to the coalition case. What are the enabling factors? What are the impeding factors in procurement policy through this judgment? So like that, I told you tradition, modernity, polarity, we applied for gender and rights of worship. You can apply many such theories to the judgment text, or you can apply to the way of court working as an institution. You have the predominant approach like doctrinal and non-doctrinal approach in legal research. I'll come to the details. Now, we may examine legal institution. For example, I had come across the Delhi University PhD research, which was looking at Central Administrative Tribunal in its 4 decades of working. How many cases, how many types of cases, which type of cases were predominant, how long did it take for each case to reach a certain stage. So that is a very useful material to see why there was delay, which judge was delaying. There is a very interesting body. I don't know how many of you have read. Please read online, Daksha. And now we have Vidhi as well. These are the research centers which are looking at, for example, Daksha studied the Supreme Court judges' way of working, and it saw which of the judges takes very long to give a judgment or declare a judgment. So they were able to compare between judges. So this helps the law ministry also to get an idea of how each judge is functioning. It's a kind of social audit of judges. We compare it with other jurisdictions sometimes. I mean, all of our researchers have a comparative chapter. Then historical, social, and cultural significance, especially in case of tribal rights and things like that, or Indian traditional knowledge, which has a bearing on IP as well. Traditional performances, like 3 of my students have worked on Kathakali, on Theyyam, they have worked on dance forms, etc. So sometimes what causes a law, or sometimes how this new law like talaq is impacting, triple talaq judgment is impacting, and sometimes facts may be new, and how old rules are not catering to these facts. What example you can give? Now we have a lot of co-created families, like, because of the transgenders being decriminalized and not outlawed but protected. So how these new facts will have to create new situations of co-creating a family, and how do the old rules impact on that? Then there are some social phenomena, social problems. For example, in Maharashtra, nearer to Pune, we came across a practice whereby the girl's virginity was tested, and it was declared in this day and age, So a good journal article came, and one of our students did an analysis. Similarly, rag pickers, for example, their insurance rights, especially in the COVID crisis. We had our article got published in Scopus Journal on the menstruation practices in the state of Orissa in certain community. One of our LLM students did the study. So there are many social phenomena like child marriage in our neighboring village we came across, and then we have created a responding team there by training barefoot lawyers. So social problems, social phenomena, these also can be the core of legal research. So my first part of sharing with you is to set the foundational understanding of legal research as a scientific research. Now, the next thing is, how do we approach? One is just simply describing what is this issue that you have taken up for legal research. So that is a descriptive research which addresses only the what question, like safety of food, which legislation, how is it defined, how does it impact. Now, judicial attitude to constitution, maybe you can take one article and you can see, or you can see interrelationship between fundamental rights, how the judiciary has reflected on, or simply Article 21, how it has evolved as a conduit between Part 4 and Part 3, so, and how it has impacted various other subsequent legislative developments. Secondly, it could be exploratory research where you try to find out why and how. For example, how the vulnerable situation is reflected on by the law for the disadvantaged. Like we had the recent Prithviraj Chaudhary case, where the issue of SC/ST Atrocities Act in conflict with Criminal Procedure Code was reflected on, and the earlier decision on Kashinath was reversed, overruled rather, and then Justice Butt reflected on the mirage of casteless society as part of that. So is that really true? Take that as a hypothesis from the obiter dicta in the judgment, and you can take a community and you can see how the law is working there. Then sometimes you can examine the institution, like I gave you the example of Central Administrative Tribunal. You can evaluate, you can conclude. Then critical research is point to the inadequacy of the law. We have this critical legal studies jurisprudence coming from Harvard and a group of researchers, where they look at law in an evaluative way and they say that law is not apolitical and the law is not what it states to be. You have to go behind the law and see. So the whole tension between gender, race, and law has been brought out by a number of researchers. So critical research is the one which looks at the inadequacy in the law. It either says that inadequacy is justified or it disapproves, and then it suggests law reform. So I say that every research that you do should have all of these dimensions, or at least that critical dimension should be built into it. Then we have the historical research, sometimes the history that people tell as well. How did current law come historically? For example, we have the notified tribe legislation. How this whole legislation came about, the bias of the British against the people who were looking in a certain way, behaving in a certain way, and labeling them as chore tribes, So how those people, when they got mainstreamed, still that NT and other tags were continuing. These things will be very interesting. We haven't done much research about our such realities. Comparative, you can compare the two legal systems. It is, people simply say comparative. You can't say. You have to see what is to be compared. What is the common historical origin in these two comparative dimensions? Second is what are the similarities? Third is what is the dissimilarity? You can see, for example, anti-drug addiction law here and in Europe. Now we have the UNTOC convention also. Poverty, for example, or the poverty within cities or poverty in rural, matrimonial laws, social security. So look at your own research problem and then see whether you are qualifying your research as analytical or descriptive or critical. And then if you are not, then you have choices from these options that I have suggested. I hope it's clear till now. Now let me take you through how do we plan to do the research. The plan to do, or the blueprint, like how when you construct a house, you have your house's sketch, right? And that's called the blueprint. Similarly, when you are embarking on a research, there has to be a design. This design is nothing but a series of decisions or conditions which have to be arranged in a certain way. These conditions could be how to formulate the problem, how to collect the data, analyze the data, how to combine the current relevance, contemporary relevance to the researcher's purpose, how we should not complicate it with too much procedure, how do you plan, how do you visualize difficulty, how do you remain cautious. So design is the decision about what is your study about, what is the purpose, what are the types of data, and where do you find the data, what will be the place or area of study, means which is the universe. Is it this village, a tribal village near Ahmedabad that you are going to focus your research on, and then within that whether every household out of 3,000 will be studied, or every fifth household is studied, and why every fifth and why not every second. So this is the sampling decision. Then what period of time depends, if it is master's thesis 6 months, maybe if it is your class projection, then class project, then maybe 15 days. If it is a PhD thesis, it is 2 years or 3 years. So what approximately is the time required? So it is your time available and the data that you design to be fulfilled within the time. So research is that linking all these links with a wonderful plan and openness to change in case it goes out of control. That is why you have a guide or a mentor who has done that journey, who will be helping you to eliminate. Research is this, just like judgment writing. In research also, what is relevant is kept, what is irrelevant is eliminated. So it's a series. Research decision is nothing but series of selection and elimination process. So what kind of cases are required? How many cases are required? What basis will be used for selection of the material? What techniques of data gathering will be adopted? Now, would you be using questionnaire method? Would you be using survey method? Would you be using Google survey? What type of sampling? Is it simple sampling or random sampling or stratified sampling, that you will divide the entire village into 4 zones and in each you will take 10 households, or you will ensure that a single parent household is included? You will ensure that different socioeconomic strata are brought in. So that is stratified. Or you will say that this community is difficult to fathom. So you have one informer there. That informer will bring his or her friends from different parts. That is a kind of what we call as snowballing or clustered. Either you take a cluster or you take snowballing, where one goes and brings the other, or probability, which is very closely knit, but depending on the people who are probably available, or volunteering sampling. So different kinds of approaches can be taken depending on the universe which presents to you. And universe is the larger community or the group, and sample is what you select out of it, but you have to justify what method you have followed and why you have followed. And then you have to say, once you gather the data, how will you analyze the data? Will you be using software like SPSS, or will you be doing it manually? How best these questions are to be decided will be based on the purpose, the money that you, suppose it is a huge grant that you have received from World Bank or something, then you may have many researchers going and doing in many areas. If it is your personal research for an LLB project, then you will have to plan it in that small nano way. So it depends. I hope it's clear. So what is the first stage in research? Formulation of the research problem. I'm coming to that first stage. When you formulate a research problem, there is a centerpiece and then there is an attribute. What is in the center and what is the attribute? Now, center, the core problem that you are taking up, has to be very clear, very precise. It has to be something relevant and having some relevance for another 2 years at least. It has to be well referenced, and you have to have sufficient justification for taking up that topic. Fundamental part which is there in the core has to be related to other parts. So that is the key to success. It has to support your conclusion, your problem you have taken, the methodology, the limit, your research question, and it has to be based on sound literature review. Means you should have read enough and reviewed, critically reviewed. How do you do that? So here the centerpiece is cybercrime. Now, research problem is difficulty, the problem that you face as investigator, as a judge, or as a researcher, you are seeing that there are reports showing the difficulty. If you can tweak increase in cybercrime during COVID crisis and the approach of the law enforcement agencies. They had real problem because they were more interested in preventing people from going to the street, and they had less time for preventing cybercrime because we were operating with the shoestring manpower in the police force. And most of the people were at home and they were engaging in committing more and more cybercrime. So difficulty in controlling it, investigating it, and preventing it, or the increasing cybercrime during the COVID crisis. So that will be the attribute. Centerpiece is cybercrime only. You can give it different attribute, either cybercrime in relation to children based on those who are impacted, or cybercrime in terms of the time like COVID crisis, cybercrime in relation to economy, cybercrime in relation to women, so increase, decrease, etc., or cybercrime in relation to national security. So you got it, centerpiece and the attributes. So centerpiece is cybercrime. The attribute can vary depending on funding agency, depending on your specialization. You may want to connect cybercrime to e-commerce. You may want to connect it to normal financial operation. You may want to connect it to law and order problem. You may want to connect it to the vulnerable like children. So this is how, with one core idea, you can evolve research problems. So this is called problem formulation. So at the end, the goal is set. That goal is either a descriptive study or an evaluative study or a critical study to determine the factor responsible, magnitude of the problem, and find solutions through law. So the rights question, the law question, through law means we have the legislation, we have the international protocols, we have the judgments. So that law question, law point there is more to be an IT Act and then amendments to the IT Act. So many issues will come. I hope I have made it very clear. Now, you think of your own problem and put it in this format. This is a simple way of breaking down the problem as a centerpiece and attribute. Now, you can ask questions like in problematizing. One is, how does law regulates or prevents? How is it result in effective protection? Or you can say, some people say to understand the problem, to explore, to investigate. But the better word be to compile best practices, to develop a legal framework, to challenge the existing approach, to consolidate, to clarify, to criticize, to formulate, to appraise, to calculate, to recommend changes to the law. So you look at your topic and you work this way, or you identify your research topic and do this kind of a thought process. So I finished the first part, problem. So when you are finding the problem, you are doing at least 3 best citations. How do you decide the best citation? One is latest. Second is lead highly impactful sources like Harvard, Stanford. You can even have ABDC journals, Scopus-based journals, at least 1 or 2. And then also seeing that latest reports are cited. So when you're writing the problem statement in an abstract form, see that you have the best citation, minimum 3 to 5 used there. Once that is accepted by your review committee, then you go to detailed literature review. Now that detailed literature review itself becomes 1 page in an article. It can be 5 to 10 pages in a LLM thesis. It can be 30 to 50 pages in a PhD thesis. So you are surveying existing literature, the documentation, published works, sometimes even unpublished PhD and other works because they may be latest. And you have to know where to source it and what is the method of locating information. So you may look at reports, you may look at scholarly works. So once you come across a literature, how do you break it down? So it is not literature we are talking about literature review. And that review has to be critical. So you take a piece of literature, let us say an article in Economic and Political Weekly. So when you are reading it, you are asking these questions. Is there a sound rationale? Does the author tell the objective? Does the hypothesis or the research question relate to the problem? Is it tested? Is there a method? What aspect of method has a bias? What efforts did the researcher make to ensure the validity and reliability? Was the study sample appropriate? Are the results supported? Is there any ethical dilemma? So when you write a literature review, how do you write? You say what the author says, citing the sources, but you also say what the author doesn't say or doesn't say well. That's why literature review writing is an art. I'll give you an example. One of my PhD students did the study on Muga silk in Assam. And her whole effort was to show how under the Geographical Indication Act, Muga silk has been a GEI. And then traditional silk manufacturers in Assam are householders, and how its export promotion does not result in benefit sharing to these traditional artisans. That is her whole problem. So she started showing a lot of literature on, first of all, the concept of geographical indication. Secondly, she went ahead to look at silk. Thirdly, she tried to show the concept of benefit sharing, access and benefit sharing. So she says, article discusses this about geographical, but it does not say who can apply, because her problem is traditional artisans, rights provided, boosting export, procedural aspect. What is not there, where her thesis is relevant, is what she is pointing out. So this is called gap analysis. Similarly, she talks about WTO's TRIPS agreement, and then she says that it has certain important point of standard of product, domestic procedure. They say sui generis and all that. But what it doesn't say is issue of market promotion, export promotion, economic and other benefit for the artisans. So by this kind of analysis, she's showing how there is a gap. That gap hasn't been addressed by any literature. That is where her research is relevant. So gap analysis resulting in the proper problem statement. So initial hunch of a problem which you present before the committee, and you get your PhD admission or LLM thesis acceptance. Then you go to deeper research through the literature review and you validate the gaps and validate the need for your research, and you fine tune your research objective, your research question, and then you proceed with the inquiry. I hope I have made it clear. Literature review. Now comes the data collection and approach, overall approach. One of the important approach is the law reform approach. In my opinion, every research, small or big, should have a section on law reform or an approach to law reform. How do you start law reform? Issues and problems that the community faces comes to the fore through the judgments, or sometimes it can be by scholarly writing, or it can be by non-governmental organization making a plea to the government. For example, somebody said about environmental pollution, a particular type of pollution by waste disposal, chemical waste disposal, National Law School of India has taken up as a problem. So in various zones, they have picked up law schools and we are doing the study. So here the method of that hazardous waste collection and disposal was in the center. So working out these issues, we saw how there were standards and norms, but they were never discussed on the website. Pollution Control Board's visits were not regular. So this is how you see that there is an issue that community is facing, and there is a law, but there is a gap. What Roscoe Pond calls text and the context. How the law and life, how the law is there in the book, but not in life. So then the consultation paper is prepared, then it is circulated in the community, and then the suggestions are sought. And then then the one who takes up this law reform research recommends reform recommendations. I gave you one example of agrarian workers. We did it on agrarian workers. Chennai did it on construction workers. Then National Law School Bangalore did it on domestic workers. Similarly, we had our experience last year. Our students won an award. That was on Dr. Menon's year before initiative on uniform civil code. So our students took up the adoption issue, transnational and intranational adoption. NUJ's Calcutta took up marriage. Some other law school took up divorce. And we were talking about how a neutral secular code will look like in this area. We had another research where we won the top award in national level. That was on how community land called the cow grazing land was disposed of or was being used by government in the sense of public purpose, but it was actually doling out in peanuts to big industrialists. So we were able to show it in Maharashtra with 4 case studies. So thereby we said that there needs to be a national level policy addressing such lands which are meant for public purpose. And it is a high time we revisit our right to property judgment and the right to property as a legal right in the constitution and the mechanism of execution, because property is a very important resource for national development. So we won an award. We also won an award when we suggested law reform on better participation of women in panchayats. So one is that. Second is, in your suggestions, you can talk about other catalysis like ministerial intervention, policy intervention, media intervention, educational awareness intervention, legal aid. So those are the other catalysts. Now, that is about law reform approach. Now, when you do a legal research, there are 2 categories. One is the doctrinal approach, where you have the problem or the issue or the question, either purely theoretical, traditional, armchair, whereby you try to get new knowledge on that. How many new case laws have come? What new legislation has come? Or you may say where the logical and analytical flaw is there and how it needs to be addressed. Or you can also evaluate efficacy of that judgment or law in terms of justice, fairness, protection of rights, freedom, and liberty. So that is doctrinal analysis, which is very theoretical. Second type of research is addressing the issue in the social context, like socio-legal research, like the Uniform Civil Code. We did the case study of parents who wanted to adopt, what are the problems they faced, how the current guidelines and their implementation were far from reality. Similarly, we looked at 498A with the Domestic Violence Act, and we saw how the two did not get harmonized. They were passed in different contexts with two different types of approaches, and how because of the gender discrimination and disempowerment, this was not really working in favor of women, and how new changes had to come. So in social legal research, we are looking at law in the context of a particular community, or how law is operating by visiting the stakeholders. These stakeholders can be judges, retired or working, lawyers, youth, litigants, and also NGOs, sometimes even community organizations. Like in sex workers case. So using techniques of social science research, we have Pauline V. Young's book on social science research method. We have other standard texts. So social science research looks at how social phenomena can be scientifically studied. I already narrated it to you in the beginning in the research design approach. So you may look at efficacy of the law. Is the law really working? If it is not working, why it's not working? Is the law initiating that social change, or what are the social changes which require law to be reformed? So that is how it is done. And then you look at the behavior, pattern, event, phenomena, value, attitude on hypothesis-based field study. For example, standard hypothesis in law reform we use is that the law is either absent or that the existing law is inadequate. We use only these two types of hypothesis. We don't use any other kind of hypothesis because, as I told you, law is not a phenomenon in isolation. So it is very difficult to prove the variables in case of general hypothesis. For example, whether anti-smoking law is effective in college areas, whether anti-smoking law is effective in business enterprises, and you narrate the behavior of the people who are into smoking, or that whether Vishaka guidelines, now we should say POSHA Act, is effective. We had a Delhi University study under the guidance of Dr. Raina, where the student compared two hospitals, one in private sector, one in public sector, where women were densely employed, about how POSHA Act, Prevention of Sexual Harassment at Workplace Act, was efficacious. And it was very clear that in both the enterprises, among two enterprises, private sector was much more aware of it. It's like how Supreme Court talked about POSHA much later. It is like that, government enterprises have not done initiative. So if you compare, doctrinal research is about explanation, discussion, argument, opinion on a text of law, which is in the form of legislation or judgment. Its method is about obtaining and examining information on systematic basis, maybe 5 years judgment, 10 years judgment, not including all, but again sampling, which are repetitive to be eliminated, identifying the nature and governing principles of law. Whereas in social legal research, we have verifiable, testable evidence, and we have a hypothesis that law is inadequate or law is absent. We look at the realities which we uncover by case study method or by survey or by interviews. And then this has original research because it brings that original reality of the community. Therefore, there is better recognition to the usefulness because that community is in want of a better law. So this is how what we do is, even if students do doctrinal research, we mandate them to do 10 to 50 to 100 stakeholder interview and or stakeholder data. And these stakeholders, as I already told you, are judges, lawyers, etc. in the legal system, and their opinion is captured, and then the conclusions drawn on the doctrinal basis, on the basis of case law, legislation, etc. from the text research or library data research is tested in the light of this, and then finally recommendations are drawn up. I advise all of us follow that method. We need to distinguish law here in doctrinal research, not just as working law, but in doctrinal research, they are looking it as a set of rules, it's a structure, it's a jurisprudence, it's a socio-political force in the critical legal study. So I won't go more into detail, but in doctrinal research, one message I want to give you is what Christopher Langdon the father of this case study method in Harvard, case law method, spoke about. And this method is the IRAC method, where you take a case text either from the judgment or from the narrative, and then you look at what the question that court must resolve, I issue, and then which is the rule which is governing, where is that rule coming from, what does the rule read, break the rule, and how does it connect to the fact, and then apply to the fact of the case, that is application and analysis, then conclude what result is required by this application. As a lawyer, you will want it to be in favor of plaintiff or defendant. As a judge, you would want to see where the stronger right is, or as an academic researcher like us, you will see what has been the march of the law till now and how this judgment has been logically correct or flawed, or in ignoring certain facts, or in highlighting unimportant facts. So that is our job. Analysis of the ratio decidendi in a given judgment, or the way in which the ratio was formulated in lawyers' arguments. So with one case, you can have 5 to 6 types of research approaches. Using the IRAC analysis, you get the gist of the case. Such 100 cases you put together, and like a puzzle, you arrange them either in the light of a theory, or in the light of client-centric approach, or in the light of evolution of the law, or changing of the ratio decidendi. I don't know how many of you are already familiar with this word IRAC. If you're not, I hope this has given little introduction. Deeper analysis, we don't have the time, but we can always do. You can read also. Second is legislation. An ordinance or an act or a bill. How do you read that? When you have a text of the legislation, let us say POSHA or some legislation, look at the preamble. It will give you the purpose, application, which year, what results they expect, what consequence. Second is, what are the provisions there? What kind of definitions are given? Which kind of rights are defined? What authorities are created? What remedies are given? Who has the rights? Who has the privilege? Who has the duty? What are the remedies available? How are they to be dealt with? Are there punishments or compensation? How does it impact the existing other legislation? Is it mentioned? For example, when Nursing Commission Act was analyzed by us, we saw that existing nursing categories were differently mentioned by aligning with the International Labour Organization. But what it didn't mention was the transition of certain highly talented nurses into medical profession, whether there has to be an alignment between Medical Commission Act and Nursing Commission Act. That was something that we wanted them to reflect, aside from other state legislatures and things like that. If a legislation is retroactively impacting, backdated, then what kind of impact it will have on existing cases and rights expectations. That is also a critical analysis that we have to do. So this is how I create a checklist and make my students to do the research. I already told you the examples of law reform research. One example in Indian context is that when you are doing research nowadays, robotics and life, then decision making by the judges, what kind of complexity comes in, your own legal bias, self-awareness, and understanding judicial ethnography, some judges, how they behave. And some examples can be the cases which are coming before the Supreme Court, whether in abortion decisions or decisions which are biased in district court levels. A lot of research needs to be done. Now with the e-justice website, you should be able to look at this data, live-in relationship, prevention of domestic violence, or anti-women bias in some judgments, microanalysis of consumer law and medical negligence. One of my students, an orthopedic surgeon, did the National Commission's decision, State Commission's decision, and Pune's own consumer fora decision on medical negligence only in orthopedic cases. So how then that was a triangulation method, because he also looked at the community, he looked at doctors, and he looked at the judgment. We had the Memon death case, and how did the media reflect it? Or ideological effects in case of judges. I applied it in case of Shabarimala. And the culture gender cases. And unpublished, I did one analysis in a public hearing case on the bias about the girl who committed suicide due to dowry harassment, and the judge saying that girls commit suicide because they don't know how to adjust in husband's house when they go from cities. So this kind of bias, how it creeps into judgment texts, was something that we analyzed. There are Israeli studies in Journal of Empirical Legal Studies, which are looking at even subordinate courts' behavior. So behavioral studies. So this is how we can have number of research projects as far as India is concerned, thematically, system oriented, theory oriented. Now, what is a good quality research? How do I assess if a research is a good quality research? And is it impacting research? One is it comprehensive, profound? Is it using different methodologies? Is the data wide? Is the data indicating all sorts of reality? Is it relevant? Is it relevant now and for another 5 years? What is the quality of data? I told you, good journals, good resources, latest, contemporary dimension, then scheme and flow of questions, whether from the title to the objective to the questions to the conclusions. Is there a line flowing? How logically it is coherent? Are that knowledge nicely arranged, like how I showed you the Moga silk case, whether the literature has been drawing those categories and divisions and then they are used in the chapter titles and research questions and hypotheses. Is the methodology, what kind of methodology they claim and they have used a combination and they have brought in a maximum comprehensive nature of truth? And is the reference rich? Is it exhaustive? How is it presented? Are there grammatical errors? Are the footnotes in the consistent one method? Is the style good? Is the bibliography proper? Then we look at ethical compliances. So from the research, you can always publish. You can publish case studies. You can publish legislation analysis. You can look at theoretical. You can look at policy paper. You can even publish a book out of your PhD. You can look at connection between your theme and constitution, your theme and human rights, your theme and science, your theme and family law. So then you edit and you publish. So every article is like a mini thesis. Last point I would like to highlight is about how to be responsible in conducting research. Usually you should have a research advisory committee, and that committee should look into a checklist of ethical compliance. One is it involving human subject research, collecting data from people? Are these human subjects vulnerable? Is there any risk? If there is no risk, then you allow. If there is less than minimum risk and minimum risk, simple approval after verifying certain questions, whether they are mindful of compliances. What are those compliances? I'll tell you. Thorough review if there is more than minimum risk. Like if you don't have an idea of, for example, when we did with sex workers, we did not know that we had to destroy the data because these women had narrated the names of police officials who had tortured them. So if it had gone into their hands, there was a risk. Therefore, risk is not only in asking questions, but even preserving data or in giving access to or reusing that data. So consent should be obtained. Pillars of responsible research is preventing such risk by this ethical and approval committee deliberation. Second is communication, the process of communication and evidences. Third is informing them and obtaining their consent in writing. If they can't write, then their best friend should be there and it should be translated. Compensation in case there are expenses involved. Balance of their rights and our rights, relationships, respect for the dignity, autonomy, and privacy. It can be own risk for researcher also, law and order risk, as I gave you the example. I mean, we had risk in dealing with the traumatized women who were always in the influence of drugs and alcohol. It was affecting our mental health as well. We also had to take thorough counseling. Your own safety, the life due to uncertainty of the findings, and then harm by others. All these have to be taken into consideration. Compliances should be strictly followed, especially when human subjects and the vulnerable. Who are the vulnerable? The one who is susceptible to harm. Now, who are potentially lacking capacity or have impaired capacity, and it may include both adults and children. Don't always think of children alone or demented alone. Even the normal people, when they undergo trauma, they can become mentally impaired for some time or longer time. Brain impairment, learning disability, mental health patients, frail older people, asylum seekers, homeless, traveling community, bereaved or victims of abuse, drug users, and family carers. So in this case, we have European guidelines. We have the UNICEF ERIC guideline of 2017. So they say that dignity, privacy, duty to inform them, consent and obligation to notify them. This is important milestones and checklist for vulnerable research, confidential protecting data, treating them like owners and creators of data and not just as informers, particularly when you gather data from children, and restricting reuse and not telling them that I'll take you to medical doctor and get you treatment and counseling, give me the data. There should not be any such incentive shown. Preventing harm, protecting them, respecting them, their welfare, their justice. In the Indian context, we have all these as vulnerable: women, children, OBC, SC, ST, minority, differently able, senior citizen, substance abuse victims, sick, illiterate, unorganized worker, migrant, internally displaced people, people living with HIV, AIDS, sexual minorities, and poor in general. And here, whenever we are using the data, especially in case of children, you have to use it, you have to conduct research on them only to identify their need and to do good to them. Simply don't use them just to have your data on children. Have in-depth research, use participatory method in a playful context, have a psychiatrist or a social worker with you. Otherwise, don't go near children. You have, on the one hand, responsibility to uncover the truth, but on the other hand, you have to balance their inclusion as well. Don't use them like objects to get your information. This is most important. And always, adults who are working with children and adolescents, the case records, the peers, all these have to be used, but their own responsibility also should be reminded to them, and adhere to all these guidelines and use the research only if it is the best interest and beneficial. It protects them from harm. These are the checklists: participation of children, obligation to prevent harm and suffering, counseling and complementary services to be given to them. Otherwise, don't go to the research, and your research and advisory committee will allow only if these conditions are fulfilled. I request you all to dispel your own ignorance and give a clarity that human subject doesn't mean simply human being. Their body, mind, soul, and persona are to be integrated. Many times when we asked in the checklist, does this involve vulnerable people? They said no. Actually, it was involving information about mental health. So when it is mental health, it is a persona, total persona, body, mind, and soul. So please remember to respect the dignity of your informer. Particularly, your responsibility is higher if that informer is vulnerable. So please always deliberate choices with your research approval committee. Let your research approval committee have philosophers, journalists, or public thinking people, lawyers who will reflect on this, and medical scientists, clinicians, because they would be trained in this. There is a NIH, British National Institute of Health, online training as well. You can attend that. So only then your truth OH is complete. I hope I have covered all the dimensions. I have taken a little extra time. If you have any questions, you're welcome. Thank you.
Yes, thank you so much, ma'am. There are so much questions that has been asked by students and other viewers. Uh, with your permission, shall we go with that, ma'am? We were so
Yes, ma'am.
engrossed
You can moderate. Yeah,
your
yeah,
explanation. Yes,
yeah.
ma'am. First, it is asked by Hiral Shukla, ma'am. She is just asking that what are the issues or concerns while doing case study research in legal field?
Yeah, the word case study is different from the word case law. I gave you the example of the case law where there is a reported case law text from any of the court reports. But in case study, it is a representative sample from a universe. So there, your publishing will have four parts. First part is the general theoretical and contextual background with statistics and features of that. And second is your case studies details. Third is an analysis of that case study in terms of general and the specific. Fourth is its larger implication. So in the first part, when you're giving the context, please give the literature review also in justifying your selection. And while doing the case study, you have to have accurate data, its details. For example, we did a case study in our field-based research on sex workers. I told you, we asked questions like, when did they enter the trade or sex work, and how did they enter, do they recall their experience, and then how much did they earn in the beginning, how did their earning change, what are the health issues they are facing. Because our aim was to see from these individual realities that our statistical inference is justified, and any new reality and suggestion for policy reform. For example, we thought policy reform will be more for the house, or it is for the job, or it is for dignity. They said dignity is first, and then they said that economic independence, then they said about house. We thought they were asking for house because in Karnataka house based sex work is more. Second example I can give is when we were doing on wage discrimination dimension in the agrarian worker women, we saw that this was justified by differentiation of work. They said this is male work, this is female work. So the case study was capturing how a woman who knew male work could not do it because society made fun of her as Amazonian woman or something, something equivalent in the local language. So differentiation leading to discrimination was a theory, and we did the 2 3 case studies, and then we justified how why we chose it, and we showed, proved through the case study how this discrimination continued as intergenerationally by these gender myths and patriarchal assumptions. I hope it's clear. Thank you.
Thank you so much, ma'am. It is our final year student, Kavya Javar, who wants to ask that however good efforts a student might give for the legal research, according to you, don't you think that even if it is, as it is law is a wide topic, some factors may remain untouched. So what to do for covering maximum part of it?
You need not cover all the parts, which is impossible. As I told you, it is limited by time, energy, and the requirement. For 30 marks, you need not put 300 marks effort. But on the other hand, whatever you do, if you have this checklist which I suggested to you, you can keep it comprehensive. Now, what you cannot do, what you are doing and why you are doing comes in scope, and what you cannot do comes in limitations. So in the beginning itself you can say this is covered and this is a scope, this is not covered, this is the limitation, and the limitation could be one of the three: resources, time, and energy, or access to data, or affordability. So you can justify it. Yeah. Thank you.
Okay, ma'am. Uh, Jia Mathurani, she wants to ask that while doing legal research, is it necessary to report the validity and reliability of testing results of the questionnaire, or is there any circumstances where it is not necessary to be performed?
It is
Any?
necessary because you may be doing the questionnaire with 50 people. But first, when you draft the questionnaire, you are drafting it from your angle. So it is better you show that you have done a pilot survey with 5 people and you changed the connotations of the question. You changed this question into this question into this question. This gives more reliability about you, your authenticity and genuineness, and also it convinces your reader or your guide that you have understood the methodology. It's for your advantage and the reliability of your research.
Ma'am, another student wants to ask that maturity of the upcoming generation, it is seen that children are more aware about many of the things because of Googling or many of the other resources that they are having. So, how does one go about consent of the children while researching, as you just mentioned about the vulnerable class? So,
Yeah.
can you just
See, children are not homogeneous across the world or across a village or anything. Each one's inherent capabilities, different way of perceiving the. Some adults also are worse than children. But what I'm saying is that we should not assume that upcoming generation is mature. It may appear mature at one level, it may not be mature at another level, because there are adults, like we had this Delhi High Court decision that mental age, there is a new concept coming in, mental age, not just physical age. So, from this point of view, as lawyers and as people of science and truth seekers, let's take it with a pinch of salt. Now, how do we go about? ERIC guidelines of UNICEF is very clear. First of all, if the child is able to answer in a normal circumstance, it's good. But if it is a circumstance like COVID in the lockdown season, or if it is a circumstance like a child who is in the remand home, or a child who is in a war-torn situation. Like my one student is doing, PhD student is researching on child soldiers. It's a highly sensitive research. I'm not allowing her to go ahead until she procures the ethical committee approval. Because there are so many dimensions when children are in such constrained situation, or in normal situation also, child is a child. So with the presence of the parent, first question. Second, in crisis where there is more vulnerability, as I told you, I couldn't go into the detail, you have to have a psychiatric social work trained in child psychology to be with you, and you make that person, first you sit with that person and make that person understand the questionnaire, and you make that person to be with you and mediate for you while translating those questions to the child. It's a highly sensitive area, because any harsh question, badly formulated question, can make the child reveal things. For example, in Ugandan research, they found out when there was a war-torn situation, etc., that the children were invited in a group to play, and then they were randomly asked questions by this researcher in the presence of child psychologist. But the questionnaire was only about nutrition, but one child told that sometimes I don't eat because my father regularly comes and beats my mother around the dinner time, then I don't feel hungry. So the child goes to sleep starving, not because food was not there, because the child was traumatized by the violence that his mother goes through. So such new revelations will shock you also. As a researcher, you will get traumatized. So we always advise, because children are very forthcoming, etc. Now, this has nothing to do with the maturity of the child. So we suggest keep the social worker with you for yourself also. And then this problem may need to be referred to the police, may need to be addressed by the law and order. That's not within the purview of social worker. So there are umpteen number of implications. You know, my Irish friends used to, even now they go as advisors to war tribunals in Rwanda and all other places where the Enquiry, Lubanga trial and all that, they were involved. So some of them, you know, they can't stay in the jobs because they did not deal with the trauma that they went through right at that time. So there is, it's not one child's problem, it's humankind's problem, and you and I can't be indifferent to it. Yeah.
Yes, ma'am. It is the question about the students are facing that they have started doing research, but in COVID time, there is a the research has they have become stagnant at certain point. So, what do you
Yeah,
suggest
we
to do?
used Google research, online method, Google forms, etc. Secondly, we had phone numbers of social workers and NGOs. So our students tried to do that. Wherever they couldn't, they wrote it as a limitation. And then they proceeded with the document research and a couple of informed narratives as validation empirically in a limited sense. I think that is allowed, because COVID year graduates are also looked at as with a pinch of salt. COVID year is a zero year in some sense, but we are trying to make sense out of it as a united educational community. Therefore, let us take it like that. But your own individual effort to master the methodology is more important, so that you can apply it when the circumstances become normal, and you can publish it with addendum when you are publishing it after the COVID. The other point is during COVID, a lot of students have faced mental trauma because they are not getting their peers. They don't have social, because human being is a social animal. We are gregarious by biology. So we have a lot of virtual way of relating to each other. I have created small groups, recreations, interchange of knowledge, etc. One of the ethical dimensions is you can't use your classmate as a data provider. You cannot, because it becomes biased sample, it becomes interested party and common competencies. So we have put a strict rule on avoiding college informers and students. That's an ethical rule. But nonetheless, avoiding this kind of loneliness and mental health issues that students face, counseling and other dimensions could be useful aside from online small group meetings, online imitation of the real socializing. So we have lots of online festivals, online recreations, small group interactions every evening, town halls. So this is how you can overcome. Thank you. This is a difference between research problem and hypothesis, how to frame it correctly for a doctrinal research. In case of doctrinal research, we don't use hypothesis because hypothesis is generalization which connects the different variables, and it is usually inadequacy or absence of law, which we usually use in case of empirical research. Uh, so problem, as we showed in that cybercrime case, my PPT will be with the organizers. We put the problem like a descriptive study to understand the challenges and limitations in the current cyber law to abate cyber crimes, increasing cyber crimes. You can add a qualifier during the COVID period, pre and COVID, post COVID period comparison. So, like that, you can make modifications. I hope it's clear.
Yes, ma'am. With
Or
your
you can say
permission,
in the
can we
city
just
of
take the last
Ahmedabad.
question? Um,
Yeah.
with your
Sorry.
permission, can we have the last question, ma'am? With your permission?
Yes, please, please, as you wish. Yeah.
Yes, ma'am.
How to reflect the complex process of triangulation in the conceptual framework of research, especially in the context. Wonderful question, Navneeta. Congratulations on that. Now, triangulation is a term. You should buy that Ishwar Bhatt's latest book on research, legal research methods. He mentions about triangulation as well. But I got it from Economic and Political Weekly. I have been using triangulation for last 15, 17 years. Now, triangle. The term comes from the survey science, where if you are asking about a temple or a bar, nowadays people will be more interested in bar, may not be in Gujarat but other places. So, how far is it from the school? How far is it from the bus stand? How far is it from the railway station? This is how the triangulation concept came. So, explaining the location of a place. In our research, explaining a phenomenon. So, when I'm trying to explain the problems faced by sex workers in Karnataka, female sex workers, and the policy formulation required, I view it from the statistical survey among 10,000. I view it from the qualitative case study among 3,000. And then I do a focus group discussion with all the stakeholders, such as IAS officers, district police officers, district executive officers, social workers, health officers, sex workers' own organizations, non governmental NGOs. The expert advisors like psychiatrists and doctors. So, in that focus group, I put together my conclusions and policy suggestions and make them discuss. So, in all three, I am able to address different needs of my research objectives and my findings, and then the real outcome, which is policy reform suggestion and policy reform structure. The structure we suggested was an interministerial task force, because they had created a new scheme which had certain reservation of 20,000 rupees for a sex worker, which was being utilized to the extent of 0.02% because she had to come and declare she's a sex worker. So, when these women value dignity so much and you are building it on stigma, how can it work? So, we showed how that policy has failed. And we showed that there was no need of that policy to be in isolation. It had to be with the 60,000 crore allocation with social welfare, which could have been interconnected. So, we suggested interministerial committee. Now, this is triangulation. Now, another triangulation example I can give is we did it in the media research, where at that time, the first film, Chandni Bar, came on, Dance Bar Girls. So we wanted to show the narrative of this Chandni Bar film, and the researcher met six dance bar girls, bar dancers, and then she correlated film text with their real life, and there was so much of matching, and then she suggested how the solution to their problem needs to have a multi-pronged approach. So, text to context through the lens of a film in terms of rights of dance bar girls. This is also a triangulation, because film text, real life text, and the legal text were interconnected. Human rights text were interconnected. So, one person or one location, which is that subject of research, and then different approaches are the qualitative feature of triangulation in order to explain that phenomenon and problem and suggest a solution as required either by the project or the grant agency or by the requirement of your degree. So, one criticism against this was that, is it explaining or explaining away? That is the care you have to take, where to stop, where to limit, how to make those choices. Your design has to be very clear.
Okay. Okay, thank you so much,
Dr.
ma'am. That was very apt answer to the questions that were asked to you. Still, there are many questions, but you have already given
Yeah.
answers to them in your explanation. So we are just avoiding those
Yes, ma'am.
questions because many students are asking the same thing which are already been explained.
Right.
So as I said that once PPTs are shared, I think they'll be clear about it,
Yeah,
whatever
I'll
has
mail
been
you right
already.
away. Yeah.
And moreover, this stream would be this link would be streaming, so it would be
Okay.
easy for them to see and to understand it again and again whenever they wish to, and whenever they are stuck with any of the difficulty. And we are
Okay.
so thankful to you, ma'am, for explaining such a technical yet very difficult thing, that is especially about legal research methodology, and that too contemporary approaches to that. I'm sure that not only student fraternity, but all the members who are viewing it, all the people, all the faculty members and experts, they also learned many things because you explained in so many in so good manner, ma'am, that we were just engrossed with the flow that you were explaining different cases. You were giving example. It was complete with exemplifications of different places. And the best thing that you said is that research is just like judgment writing, that you just have to include the important things and you just have to keep eliminating inappropriate things, or those things which are not or less of less important. And yes, we came to know about the vulnerable class specifically, that it is not limited to only children or only to those who are physically or mentally disabled, but there are many women, minority, LGBT, they all are a part of vulnerable class, and they should not be treated. The best part was they should not be treated as subject solely, but in your words, as you truly said, body, mind, soul, heart, all these things have to be taken into consideration for making any research on a persona. So, ma'am, this is the takeaway that we have received from your lecture, from your session today. Looking forward to have it more, because it is very difficult to include research methodology, such a wide subject, in a nutshell, and that too from a person like you. And ma'am, we hope and we wish you a very fast and happy and excellent recovery,
Thank
because
you.
on the last day to work from home, you are explaining it with such a dedication. When it came to explaining your things, you were completely into it, and nothing could be seen except
That's our
the
job. Yeah.
expertise on your session, ma'am.
Thank you. All the best and Happy New Year to everyone, to Dr. Mayuri, yourself, and all the faculty members and the students and the audience. All the best. Have a great year ahead. Thank you very much for the opportunity. Dr. Mayuri, thank you once again. Take care. Bye bye. I'll send the PPT. Yeah. Thank you.
Thank you so much, ma'am, once again.
Thank you. May I
Thank you.
take leave? Yeah.
Yes, yes, ma'am.
Yeah. Thank you. All the best.